Hi, everyone. Dr. Maria Sampoulos here. I have a guest, a lawyer today, Stuart Oberman. Hi, Stuart. Thank you for joining the podcast today.
Dr. Sampoulos, thank you so much. I've looked at what you've done in the podcast, and you're in the industry and you're in the trenches. So it's really a pleasure and honor to be on your podcast. I know you have a very, very deep following. So again, I'm very gracious with your time and consideration in having me on your podcast.
Oh, thank you. All the doctors are talking about the non-competes situation going on, and that affects a lot of doctors, practice owners, employees, even people in industry. So I wanted to have an expert on the show to talk about it, to have questions. And then if somebody wanted to ask a question or email you after the fact, can you provide an email address for our listeners?
Oh, absolutely. Feel free to reach us, Stuart, Stuart, at Oberman, Oberman, law.com.
Excellent. And just a little background on Stuart. He is the founder of and president of Oberman Law Firm. He graduated from John Marshall Law School, where he got and he's been practicing for over 30 years. Before private practice, he was in-house counsel for a Fortune 500 company. And, has done a lot of things in the industry with DSO formations, corporate business structures, mergers, acquisitions, list goes on. And, HIPAA, compliance, law, a lot of things that affect us as optometrists. And he's been a national lecturer in various publications. So again, it's an honor to have you on the show and to be able to talk about this topic, because it affects a lot of us now with new things going on in the industry.
There is so much going on. I mean, this could be a 6-day topic. So I know we try to provide some basic information. And every state is different. I mean, we got trends, we got updates, but for the most part, every state is different. Localities are different. Regions are different. Entities are different. So it is a moving target, as we say, and it's a chore keeping up with everything that's going on, for sure.
Of course. So just give us some status on the FTC's attempt to ban non-compete agreements.
Oh my gosh, I don't even know where to start there. That's so. What's happening is the non-compete agreements are clearly under state and federal scrutiny. So we got to take a look at the federal government is taking steps to act, under President Biden's 2021 executive order promoting competition in the American economy, of course. So, but what happened was in January of 2023, the FTC, in their infinite wisdom, proposed a new rule, which, if enacted, it has not been enacted yet, which is the key. We got a lot of guidance, but it would nearly create a ban on non-compete agreements, which is extremely dangerous. So again, it's not final yet. They're looking at a lot of things. And there's going to be, if that rule is enacted, it's going to be a lot of pushback. I'll cover some things on the FTC stuff, but you're going to have, one, whether or not they have the authority to do that. Two, whether or not it's the legislature issues. So we got to take a look at one key on this non-compete issue with the federal government and the FTC. So they're carving out exceptions, right? So the sale of a business is a big carve-out exception. I anticipate we're probably going to have maybe multiple revisions. But if you look at the rule, it's really fancy. It's, Executive Order 14036, which directs the FTC to curtail the use of non-compete clauses and other clauses agreements that may unfairly limit worker mobility. Well, FTC is sort of putting a strong arm on Section 5, which will allow them to do that. But then you've got workarounds, if you will, what we call de facto non-compete clauses, where, employers are going to look at, repayment of training costs if someone leaves early. They're going to take a look at, executive compensation clawbacks. They're going to take a look at retention bonuses, clawbacks on retention bonuses. They're going to look at, incentive compensation. But I really want to take a look at one thing that the FTC did recently. Again, I could talk 17 hours on FTC, but this will give an idea of really the optometrist really where this is going. So the FTC released a federal press release, January 4th, 2023. This is dangerous. So what they did was they took extreme action against 3 companies and 2 individuals. So the FTC ordered that immediately these companies and individuals stop immediately enforcing their non-compete. They were stopped threatening use of non-compete, and they were imposing restrictions on the employers immediately as to how they can utilize non-compete. Specifically, again, very dangerous. The FTC banned in one swoop, banned communication to any relevant employee or employer that the employee is subject to a non-compete, which means that if a doctor wants to leave go for another practice, if this FTC ban is across the board, which is not, but if it is, that third party has no idea there's a non-compete, which is very, very dangerous. And then you've got requiring companies to notify them immediately, the workers, that it's nullified across the board. They're non-competes. If you have a company, that has 30 to 50, 100 optometrists, right? Again, assuming this applies to not optometrists, it doesn't right now, but across the board, the company would have to notify optometrists that their non-compete is null and void. That is really crazy. And then they have to provide every employee of that company with a copy of the order via text, email, or in writing. So that's the world within which the FTC is really utilizing now. I anticipate there's going to be some pushback on the FTC issues. It's still a work in progress. I think as they become more restrictive, there are going to be some pushbacks on the legislative side and probably on the litigation side. But it's a work in progress.
Yeah, I think there will be some pushback. I know in optometry, I reviewed a few contracts over the years and helped a lot of ODs. And, one of the things that I really look at is the non-compete section. And I say to the doctors, this is really outside the range. Like it's supposed to be, 3 to 5 miles, depending on the thing. But, 15 miles is ridiculous. They have multiple practices. Now you're working between those 2 practices. Each is 15 and Rhode Island's small. So now you have a larger, right? And so it's hard. They kind of keep you locked in where it's hard for you to look for other opportunities. Maybe it's just, hey, a practice for sale happened 5 miles down the street and you want it, you want to expand. And you can't do that because you have a non-compete. I've seen that. And then the other thing I've seen in with some of these contracts too is the non-compete increases as you stay. I just saw that. That's a new one for me. And I tell doctors that's a red flag, and I know currently in California, non-competes for optometrists are illegal. So some optometrists do not know, like you said, specific state by state. And I encourage optometrists to know what their state laws are. If they see that in a clause in California, whether it's an employee position, sublease, let the corporations know or the employer know that, that information, that it is illegal. So you are comfortable with what you sign and know what you sign because with any contract, right, you need to know and be very clear of what the expectation are if you leave. And I think sometimes as well, there are clauses that show penalties. And the penalty fees are very large. And I say to them, you sign that? Take that penalty fee out. You never want to have that. Now, from the employer standpoint, as me being the employer, optometrist, the small business owner, we're not talking about, it is this new law is also upset. It might be a little terrifying to employers because now you have an OD that's worked for you for 20 years. They've been great. They've been helped. But now what stops them from opening across the street, and for what your business to help your business. So it's that as well. So there's a lot of different moving parts here, I think. And, there's pros and cons to this, I think, for optometrists, whether employed or, self-employed. So we're going to see how it all pans out in the end. So.
Oh, it's a moving target. There's no doubt about it. there's a lot of commentary and there's a lot of things that, what could happen. It's like the news, what could happen, what not could happen. It's like pre-game show. So yeah, there's going to be a lot of pre-game show on this one. And there already is, really. There really is.
Yeah. There's a lot of conversation about this. Doctors are really paying attention to this. What is the national trend regarding restrictions of non-compete agreements?
Ooh. So it really started clamping down in 2022. So you've got to look at, we've got 5 states, District of Columbia then enacted legislation that will limit non-competes. So then we have 18 more states that have proposed or has pending legislation. So sometimes it's regional, but we look at the states as significantly what do they restrict. So I mean, if you look at the leaders in bans, California, North Dakota, Oklahoma, Washington D.C. I mean, how much competition can you have in North Dakota and Oklahoma? I mean, it's I don't really understand that. So they pretty much ban non-competes with a caveat. There's always exceptions. There's always exceptions. So then we look to the big ones, right? We got Colorado, Illinois, Maine, Maryland, New Hampshire, Oregon, Rhode Island, Virginia, and Washington. So, and they also prohibit non-competes, unless you've got certain thresholds. So, I mean, you've got a lot of restrictions on these states, but they each got carve-outs. So you've got to really look at, a lot of the, the corporations, if you will send out, to the optometrists and their doctors and, blanket non-compete agreements, and they don't even apply to the state. So you really got to take a look at what state you're in. If you got a California contract, which is not uncommon, and then all of a sudden you're in Rhode Island, you're in North Dakota, you've got problems. I mean, you've got some problems. But if you take states like Iowa, Kentucky, they limit the non-competes in the healthcare profession. So they've got gaps in there. But I think the national trends are really limiting use, the protection of trade secrets. The key on these non-competes is they don't want the employers, they don't want the doctors going somewhere and stealing the patients, stealing the list. So within these non-competes, you sort of got built-in non-solicitation clauses and those kind of things. They're looking at minimum threshold salaries, term limits, when post restrictions. And we can certainly get into what sort of the base guidelines, maybe a little bit. But we got the employee notice. What's the time considerations on these requirements? What do they look like? And then you've got the recourse, back against the employees. How are you going to issue a restraining order? Is it liquidated damages? If they violate it, is it specific? Is it 4 months of your gross pay? Is it injunctions? So there's all kind of punitive things that are looked in there. A lot of these contracts will have immediate injunctive relief. So our doctors don't realize that, even if they violate it, I mean, they can have an immediate cease and desist on a lawsuit, depending on how valuable and how knowledgeable that particular optometrist was in that particular practice. So there's a lot of things in the boilerplates, if you call them, that our doctors have a tendency to overlook. So it varies on a national basis, but that's really that's pretty much the trends. And Maine has a requirement that anyone below, I think it's 400% below the poverty level, there's no non-compete. So it really, in Massachusetts, is a whole different ballgame. They've got carve-outs and certain age limits and those kind of things. So it's all over the map. It's all over the map. But
I think
go ahead.
Sorry, I think it's come about significantly now with like the Great Resignation and how hard to find people. I know that they've given above average salaries sometimes to opticians, and they make them sign a non-compete. right? Just to kind of keep them there because they're giving them a sign-on bonus or they're above average salary right now. So these companies are kind of using it like that as well. Some of the situations with doctors of optometry are they rent spaces in retail setting and they have a non-compete, but they're renting space. So what I've seen is, unfortunately, sometimes they are in California and it's there. And so doctors just need to be educated. And, if it's in that state, it's that state. Does it matter if the company's in Delaware? I think it says a Delaware company a lot of times. It's state by state where the doctor is, correct?
Yeah. Oh, well, so you got a doctor working in Rhode Island, but he signs a contract that says they're subject to the jurisdiction of California.
Yeah.
We look at that immediately. It's like, whoa, no. And so you've got a lot of those jurisdictional issues where you're stuck. And a lot of times, like you say, they sign it or they don't. And it gets tricky, it gets dangerous, and it's, potentially career threatening depending how big the location is. So no, I agree.
Yeah. And I tell a lot of doctors sometimes with optometry contracts, things are negotiable. They might have this set contract, but it can be negotiable. There's a lot of things. It depends how much they want you and they need you. And sometimes, an opportunity is not a good opportunity. I'll tell a lot of doctors. So just be, so sometimes be careful of that. Don't just look at what the figure is and the hours of operation. There's a lot of other, tangibles and intangibles that you need to measure for your own self. And you have to kind of think of yourself at, the 1 year mark, the 5 year mark, and the 10 year mark. That's how I think. Yeah. That's how I think when I look at an opportunity. It's not just income based or that. How is this going to help me to get my goals? And what is my goals from now? And it might change, right? But you don't want to be locked in. And, non-disclosure agreements are a separate topic and all this. So that comes up in optometry too. But also in the industry for speakers and things like that, they have non-competes and certain companies enforce it more than others. But I always say, in my practice, each patient's different. Each product is going to be different for certain patients. So, for those of you that are, listening and you're young ODs and you want to be a speaker in the industry, you want to be an advisory board, know that, some do that. Speak to other ODs out there because, sometimes they do take them out and they do make exceptions. So sometimes it might be just that standard contract, unfortunately, and then they just see whatever they can get away with.
Well, but you got a great perspective because you got a great platform, right? You get a lot of doctors that will consult you on a lot of things, but also you're in the trenches. I mean, you've got the practices, so you see the best of both worlds.
Yes.
So I mean, you're right there. You're right there in it.
Yeah. I do. I like to mix it up. And it keeps me on my toes, and so I don't get bored too. You see patients, and you want to make a difference too. So
I just got an exam. It's all proverbial. Number 1 or number 2. Number 3. I didn't know. It's been 2 years. I didn't know it went to 4 to 5.
Yeah, you. I guess you weren't answering the questions correctly. That's why. So that's why we got to 4 or 5.
It's only for the lawyers that we go 4, 5, and 6, right?
Can you give us some exceptions where non-compete agreements aren't enforceable? And also, I want to touch upon if a practice is sold, how that works.
Yeah, this is the biggest carve-out exception, and this is a great question. So we don't see a whole lot of exceptions on the standard, associate agreement, but what we're seeing really, and California is really taking the lead on a lot of these because a lot of the other states are taking out these carve-out exceptions. So sale of business, goodwill is probably the biggest scenario. Is that if you sell a business and you don't want that seller going to work for a competitor or nearby because you're buying statistically. I know when we do the mergers and acquisitions, like last year we did like 147 acquisitions, mergers. So 80% of what you pay as a standard rule when these acquisitions is goodwill, maybe sometimes more if you're on the corporate side. So you want that seller to sign a non-compete. That's the biggest thing we see on the sales side. And then, how do you dispose of an owner's interest partnership agreements, in disposing of assets. That's another big carve-out exception. Then you've got sort of the accounting scenario of business and goodwill. But a lot of it has to do with getting into a business, buying a business, getting out of a partnership, getting into a partnership, and then connections. I would say most of what we're seeing is on the limited liability side. We don't really see a whole lot of professional corporations anymore. Most of it is on the buy-sell side for liabilities. But that's a great question. That's probably the biggest sticking point, is that really across a national basis, we're seeing carve-out exceptions on the sales because they don't want the sellers, again, doing a non-compete. Because if you got $1 million practice, statistically, I'm going to go very general. We're not talking about, corporate buy-ins. We're not talking about buybacks. We're not talking about capital investments from your sellers. But doc-to-doc sale, right? Doc-to-doc sale, I'll use that. If you got $1 million practice, $800,000 is allocated to your goodwill.
Wow, that's big.
$800,000. So because you got different capital gain structures, you got ordinary gains. So if I'm an optometrist and I'm selling my practice to a DSO, right, or an organization, I may go 90. I may go 900,000. So again, on the private side, and the banks will require these carve-out exceptions or non-competes also. They're saying, look, if I'm giving you, $1 million, and you're going to give it to a seller, how am I protected on my $1 million investment? Or or even on the management side, the corporate side, they're saying, look, I'm paying you 1.2 or 2 million. 1.5 is cash. I'm gonna hold certain things in abeyance. I'm gonna hold back maybe 10% on some liabilities. I'm gonna hold back, certain protocols for 5 years. You're gonna have to hit certain numbers. I want to non-compete. You're not walking across the street. So that is a tendency really to be the biggest carve-out exception. And they're almost, the states are saying these are almost non-negotiable exceptions. That's pretty broad a statement, but that's the biggest one is on the sales side. And I get it. I get it.
Yeah, I mean, that's important.
Yeah. There's a big difference from someone walking across the street stealing a patient list or 5 miles down the road, or a seller being paid $800,000 cash, and someone is worried about going 10 miles down the road. So that's a great question. That's a great question.
For states that have favor non-competes, what are some basic guidelines, and what should optometrists on the seller side as a self-employed OD and employee OD, what should they look out for?
So if you got a OD that's private practice, so first and foremost, independent contractors can be subject to a non-compete. No question about it.
Okay.
Just about everyone within the optometry practice can be subject to a non-compete. Technicians, executives with access information. So the biggest test on non-competes is, what's the time limit? Is the time limit reasonable? Is it 1 year, 6 months, 18 months, 24 months, or 5 years? The higher the number on the sales side, or that's higher on the non-compete side. Generally, they can't be overly broad. They got to be geographically specific. You can't say, you can't work in 9 counties, in California. That's huge. It's huge. Now, you can say, you know what? We're going to restrict you 2 or 3 years. That seems pretty reasonable. Now, depending on the size of the state, Rhode Island is different, from Texas to, Washington. You may have, depending on the deal, the location, the patient population, the base, you may have a non-compete that's 10 to 15 miles. There are some that are 60 miles, which is a long way. 60 miles in Rhode Island, you must go to another state.
It's probably 60 miles in.
I mean, you just might as well go, to Massachusetts, because you're locked.
We'll have to move to Alaska or Hawaii if that's the case. Yeah.
Rhode Island, you're done. I mean, you just might as well see you in 2 years,
Yeah.
So it depends on the state, the geographical location. Now, I will say the non-competes are much more restrictive and not as tough as they are maybe in the Midwest, Southwest, or Southeast. So it depends on the region. But this is really going back years. Time limits got to be reasonable. Specific guidelines can't be overly broad, can't be overly reached. And then, what's 10 or 15 miles, in Rhode Island, maybe 70 miles, 60 miles in Texas, depending on. So those kind of variables and what's at stake and how much is that dollar amount. If you're paying a group, group practice, that's got 12 partners, and their valuation is $22 million for an optometry practice, and they're selling to corporate, you're going to have a pretty stiff non-compete.
Yes.
Because those boys aren't going to pay $22 million and have you go walk across the street, tomorrow. So again, that's some pretty basic guidelines across really the industry. And it's been that way for a long time.
Yeah, just a quick thing. So I've heard that, some have leadership positions, some optometrists have leadership positions, and sometimes, either they're the CEO of a company or in the industry. So sometimes with insurance, if they leave or terminate, the non-compete is nothing in the industry for insurance for like a year. And some have taken a break and then just come back, for that non-compete. But, sometimes, I've seen they have these golden parachutes, so they can take the year off and then, come back. Where maybe like the smaller OD that might have, a smaller, lower position in there might not be able to. And how does that change? I mean, that changes if you're super specific niche in your industry. How does that help? I mean, it's for the non-compete for a year in that area. If that's all you've been doing for 10, 15 years and you're the expert, how can they limit on an expert,
Well, the higher the sale price, the more restrictive. So
even
a lot
on
of them,
position. Even on position.
Oh yeah, then you've got clinical directors, the regional clinical directors, and you got you've got maybe one doctor in a group that has in charge of maybe 3 practices, and they'll vary that up. So it depends on the position once the sale takes place. Obviously if they got a practice that's 400,000, and we got a small doctor, 5 employees, they're not going to be as concerned, and you're not going to have that golden parachute where if you sell big group, big dollar amount, you're going to have benefits, you're going to have holdbacks. So if you break a non-compete, like, what, we'll allow you to go 15 miles, but you're within that non-compete. Therefore, you agreed that you're going to forfeit your 50,000 over the next 5 years. Mm-hmm. So you've got certain stipulations. The more value your practice is, the more you're going to have holdbacks, clawbacks, and it's going to be almost non-negotiable. And the stakes get higher when you break it, is what it is. Especially if you have the sale and your group practice, and now you're going to corporate. Now you may have a equity stake in A shares, B shares, or C shares. And if you break the non-compete, then you may lose an equity position depending on your share, or they may reduce your portion if they have a recap where that's where the money's making. So yeah, you've got a lot of executive clawbacks on certain benefits that if you're a small practice, you just don't get, unfortunately. Yeah. So there is some inequity there for sure.
So yeah, I want to thank you so much for coming on the podcast and giving us some information. I know this is, turning wheels and just going through the motions. When do you think they're going to have a decision on this or have something on it? Because they have everyone at the edge of their seat for this.
Yeah. I think the states are going to take more action than the feds. I don't think that the FTC will move quickly. I'm more worried about the National Labor Relations Board and plucking away at non-competes like they did, on this most recent decision in January. They're starting to carve out things. So that worries me more than I'm sorry, for the FTC. I'm more worried about the individual cases than I am on an overall ban. Like in January 4th, they issued a press release of this year where they cracked down on those 3 companies, 2 individuals. I'm more worried about that than a broad ban. So they're becoming a little bit more active selectively, which is not necessarily good either because there's very little guidance on that. That's a long answer for I'm not sure.
Yeah, of course. Yeah. And then even you said, like, even if they do come out with a law, right, federally, right, they say you need to get this information out to your employees, text, email, written notification. Now, I mean, that's fine, but how does that information go out to the local optometrist that might not be following the rule, and then, not do that, and if for them to implement something like this, it will take time and they need to notify. I mean, how do optometrists stay up to date with things like this?
Well,
besides their own organizations, but some people don't read emails. Some people don't they hide in their office.
Your podcast is a perfect example. I mean, just because you got to go to the podcast, you got to get the newsletters, you got to go to the associations. There's really no one source. Like we have our email is like 15,000. So we try to put out as much as we can. But they got to go to your podcast. They got to go to the business of optometry publications, and it's time consuming. So they just have to stay. They have to do the best they can to stay up to date on it, and it's hard. It's hard. It's hard enough for us. So especially for them.
No, of course, yeah. I mean, I stay up to date with the latest and greatest. I like it. You have to be good. But then I'll talk to some doctors in the industry, and I'm like, you didn't hear about that? That was breaking news, And that was Vision, Vision Monday breaking news, and they had sent an email out, and people don't check, or they don't check the business articles, and sometimes they don't get their information. Sometimes they get their information from their local reps, contact lens reps or whoever's in the area. So,
well, I know on our end, I'll get 6 to 8 industry employment law, HR publications or emails a day. So, and it's all I can do to keep up with it because it is so many moving things. But yeah, they just have to, they have to use the resources around them. And again, your podcast is a great example of that.
Yes, they have to stay up to date. They have to continue to, keep up on optometry clinically and, laws and rules and breaking news. We have to keep up on it. So I want to thank you so much for coming on the podcast. It's been a pleasure giving some insight to the doctors and the listeners of this podcast. We'll keep up to date on the latest and probably have you back on if the FTC ever moves forward or has a thing and how that's going to affect us as optometrists.
Dr. Sapalis, thank you so much for your time, your effort. What you're doing is amazing for the industry. And again, it's just an honor to be on your podcast. So thank you very much. And listeners, thank you very much also.